Welcome. I'm Matthew Jennings, an IRS enrolled agent and law student currently preparing for the tax court exam. I have doctoral credits in finance as well as an MBA in finance. I have an undergraduate in marketing and also 23 years of consulting experience, with 14 of those being related to trust. I've had a few individuals approach me concerning the Jeffrey Epstein situation and wanted me to speak on that and give what I feel would be my analysis on what would happen next. According to the research, Jeffrey Epstein passed away with over 577 million in assets, being cash, real estate, so on and so forth. One of the other issues involving this case is that he was alleged to have been a rapist and pedophile, among other things. And there are pending claims of sexual abuse, rape allegations, so on and so forth. So many individuals are interested in what is going to happen. Many people have given advice and their opinions of what they think is going to happen. And I don't really believe that anything is close to what I'm going to predict will happen. Okay, number one, we have an estate that is valued over 577 million. As you may know, the estate tax comes into place whenever there is an estate that is valued over, I believe the last figure I checked, 11.4 million. Federal tax is 40%, and there's also a gift tax of 40%, and those two work hand in hand. When the estate tax isn't effective, the gift tax comes into place and vice versa. So they work hand in hand to make sure that the government collects on the gift tax or the estate tax. So obviously his estate is valued way above that amount. So he's looking off the back at 40% taxation on 577 million. So if we wanted to just roughly round that up to 600 million and we take 40% of that, we're looking at 240 million. And that's something that has to be dealt with. When there is taxes due and not paid, in theory, a tax lien exists as soon as a liability occurs. So that has to be addressed. If the executors of the state don't address that tax liability, they can be held personally liable for not paying that tax. So say, for example, if they were to pay off lawsuits or other claims that come forward against the estate and not pay the estate tax, then they're going to be held liable for that. The IRS might even try to go after those assets that were fraudulently conveyed or given away in error. So there you have it. Almost half of his estate is gone in taxes. So you have 300 million left, a little bit over 300 million left for anyone that is making any claims against this estate. So the issue with that is there are also individuals, and I think I saw one individual that was claiming 100 million in the state. And so if there's only 300 million left, I would imagine that the dozens of potential victims that are out there would probably need to be very quick in making those claims against the state, because if they don't, they probably will not get anything. As far as the suggestion that he established a trust 2 days before his death, research shows that there was an attempt to establish the 1953 trust. Actually, his will discussed setting up a trust after his estate pays all of his debts. He had a pour over will, and that pour over will basically gave his executors the direction to, once the obligations and debts of his estate were paid, that those assets would go into the 1953 trust and it would establish that trust. So that pour over will, having had those directions to the executors to put those assets into the trust after those debts are paid. So actually that trust isn't funded yet. In theory, a trust is created when you think about it, but there's more to just creating a trust if it's not funded. So the trust definitely will not get funded. There's the estate tax that has to be paid. There's going to be too many claims and lawsuits, and I just don't see that trust ever getting funded. So when people make the suggestion that he got away with one last blow to his victims by setting up this trust, that's not true. Again, there was a pour over will, and the trust will be established after the fact, testamentary trust being established after all of the debts are being paid on the trust or from the estate. And so, again, this is what I see. I see estate taxes being assessed in excess of 200 million. I see a bunch of lawsuits coming forth out of the woodwork against the state. I see years and years of legal battles, and I really don't think anything will be left of his estate to fund the trust. And that's basically my analysis. Thank you for watching this podcast. See you next time. The question that arose from the articles is this: was he able to effectively get his assets into the trust, either by sneaking them in the trust or conveying them to the trust? So if we look at his timeline, 2 days before his death, he set up this will, this pour over will, to establish the 1953 trust. A lot goes into establishing a trust. I mean, you have the trust document. The trust document is a contract. A trust is a contract. So a contract can be put together relatively quickly. However, we have the funding of the trust in question. Funding the trust, which basically means conveying assets to the trust, and those assets can be cash, they can be real estate, they can be personal property. But assets that are conveyed to a trust, that's not automatic. There's paperwork, there's bills of sale, there's letters of conveyances, there's quitclaim deeds, there's all sorts of paperwork that comes into play in conveying those assets to the trust. There's setting up bank accounts, applying for employer identification numbers. So to say that he was able to put any assets in the trust within that time frame is highly unlikely. Even if he was able to sneak any of the assets in or was able to fast track any of the conveyances or putting in those assets in, fraudulent conveyance, I think, is going to be a claim that the government and even the attorneys for the victims will be able to successfully assert against the estate. And if they successfully assert a fraudulent conveyance claim, then any of those assets that have been conveyed, whether they were conveyed to the trust, even if they were given to someone, sold, what have you, those assets would, for a lack of a better word, be able to be repossessed and taken in to account for, again, estate taxes and any claims that the victims may assert.